Hello everyone. Laos is an emerging economy, so IP protection is in its infancy. However, an increasing number of foreign enterprises are investing in Laos, and a growing number of IP stakeholders are interested in protecting intellectual property there. In this video, we will address the issues that many patent applicants in Laos are concerned about. Mr. Quan Nguyen Vu, a partner and IP attorney, and Ms. Hoang Thi Tuyet, Ms. Dao Thuy, senior associates of KENFOX IP and Law Office, will join our discussion today. Hello, Ms. Hoang. I want to ask when is the best time to file a patent or petty patent in Laos?
Laos applies the first to file principle, meaning that priority is determined by whoever files the patent or petty patents application first. Or, if priority is claimed, the earliest priority date. Therefore, you should begin the process of filing your patent in Laos as soon as possible, and not make the invention public before filing the application. An application may contain a declaration claiming priority based on one or more earlier national, regional, or international applications, which are filed by the applicant, whether in Laos or in another country, which is a part of the convention. Therefore, Laos will accord the same priority date to application from convention countries.
Mr. Quan, as Ms. Hoang said with us, there are two types of patents in Laos. That's a patent or a petty patent. So, what are patent and petty patent in Laos?
In Laos, there exist two kinds of patents. Firstly, patents, and secondly, petty patents. Patents are defined as official certificates from the state organization issued to protect inventions that are new, involve an inventive step, and are capable of industrial application. Meanwhile, petty patents are defined as the official certificates issued to protect utility innovations. To be patented as a patent, an invention must meet three requirements. Firstly, novelty or new. Secondly, inventive step. And thirdly, industrial applicabilities. Meanwhile, to be patented as a petty patent, a utility innovation must be derived from technical improvements and involve simpler techniques than an invention in order to improve products or a new production method.
Thank you so much. So, what are the differences between a patent and a petty patent in Laos?
The biggest difference between an invention protected in the form of a patent and a utility innovation protected in the form of a petty patent in Laos lie in the conditions and the validity of protections. Conditions of protection for invention are established at a higher and stricter level than for utility innovations. The most prominent is related to the requirement of novelty. An invention meets the requirement of novelty if it has not been created, has not been made publicly available in anywhere, anyway in the world prior to the filing. Whereas, as long as it has not been known or applied in Laos for 1 year prior to filing, a utility innovation could have met the novelty requirement for protection as a petty patent. In respect of validity term, a patent is 20 years and a petty patent is 10 years from the filing date.
Ms. Hoang, how is a patent applicant examined in Laos?
In the case of such international patent applications, the Department of Intellectual Property of Laos, DIP, merely examines the formality of the application. Why DIP does not conduct substantive examination, it recognizes and accepts such an examination reports from other IP offices around the world. Upon receiving an application for patent or petty patent, DIP in Laos will conduct a formal examination to ensure that application is complete and meets the requirements. If the application is incomplete, DIP will notify the applicant who will then have 60 days from the date of the notification to respond or to complete the patent application. After the formality examination, the IP will conduct a substantive examination of the patent application to determine whether it meets the requirements for patentability. The substantive examination for patents and patents is usually based on a search of assessing technical knowledge. In the case where the patent application had previously been subject to a search or an examination by another authority or in another country, the applicant can submit a copy of that report and request that it be accepted in lieu of conducting a search in Laos. If there are no previous examination reports for the applicant is either unable to provide such a report, the applicant must request the IP to examine the application as to its substance. Notably, the Ministry of Science and Technology is required by law to undertake this examination within 32 months for an invention patent and 12 months for a unity innovation, also called patent patent, from the filing date of the application or the priority date, if priority is claimed, or of the IP's expense to examine the invention or utility innovation are charged to the applicant. After consideration and examination of the registration for patent or patent, if it is considered to meet the requirement provided by the Laos IP law, the DIP will issue a patent or a patent for that application. If there are no previous examination reports or the applicant is otherwise unable to provide such report, the applicant must request the IP to examine the application as to its substance. Notably, Ministry of Science and Technology is required by law to undertake the examination within 32 months for an invention and 12 months for unity innovation, from the filing date of the application or the priority date, if the priority is claimed, or of the IP's expenses to examine the invention or utility innovation are charged to the applicant. After consideration and examination of the registration for patent or patent, if it is considered to meet the requirements provided by the laws, the IP will issue a patent or a patent certificate.
What language can we use to file a patent application in Laos?
The application can be filed in either English or Laos. However, application documents submitted in English must be translated into Laos within 90 days from the application filing date. The translation must also be certified to be correct translation.
How long the legal protections of a patent in Laos last?
A patent lasts for 20 years after the filing date of the application, and a patent lasts 10 years from the filing date of the application. Kindly note that in order to maintain a patent or patent registration, an annual fee pursuant to IP law must be paid in advance by the rights holder.
How long does a patent application in Laos take before it is granted?
The time it usually takes from the filing date to granting date is approximately 4 to 5 years for patents and 2 to 3 years for patents.
So, what should be taken into considerations for patent protection in Laos?
Patent cancellation or invalidation, special attention should be paid to the fourth ground of patent cancellation or invalidation. After registration, you should use your patent or patent in commercial activities in Laos. Otherwise, third parties can submit a cancellation request within 5 years of the publication date of the registration to terminate your patent or patent on the ground that you have failed to employ it commercially.
2. Deadline for cancellation invalidation in Laos. A third party can submit a request for cancellation or elimination with DIP within 5 years from the date of publication in the Official Gazette on the registration of industrial property. After 5 years from the date of publication, the third party can submit a request for cancellation or demolition with the People's Court to proceed with the request.
Term protection and maintenance of the protection periods for patent and petty patent in Laos. A patent in Laos has a protection period of 20 years from the filing date of the application. In order to maintain the protection period of the patent owner must pay annual advance fees and service charges. Fee for maintaining the protection periods of the patent for the first 40 years is included in the fee and service charge when filing a patent application. The owner shall pay an official fee and service charge for maintaining the protection periods for the 5th year onward. A petty patent has a protection period of 10 years from the filing date of the application. In order to maintain the protection period of the petty patent owner must pay annual advance fees and service charges. Fee for maintaining the protection periods of the petty patent for the first years is included in the fee and service charge when filing a petty patent application. The owner shall pay a fee and service charge for maintaining the protection periods from the 2nd year onward. Before the expiry date, each year, the patent or petty patent owner can pay official fee and service charges for maintaining the advanced protection periods within 6 months. The Department of Intellectual Property of Laos will not issue the notification to the owner to pay the official fee and service charges. This office will only notify the owner that the patent or petty patent is expired, as no advance official fees and service charges has been paid. If the owner does not pay official fee or service charges within the given time, this office can extend the time for 6 months from the expiry date of the protection period, but the owner has to pay fine for the delay.
I believe that many IPR holders are interested in obtaining their patent rights in Laos at the earliest time. So, are there any ways to expedite patent examination in Laos?
A patent application in Laos can be accelerated in several ways as follows. Accelerating patent examination by using the Asian Patent Examination Cooperation or ASPEC. ASPEC is the first regional patent work sharing program among 9 participating Asian member state IP offices of Brunei Darussalam, Cambodia, Indonesia, Laos, PDR, Malaysia, the Philippines, Singapore, Thailand, and Vietnam. You may consider using ASPEC if you have a corresponding patent application as any 2 participating IP offices, and one of the offices has issued an examination report indicating at least one allowable claim. A patent applicant may submit a request in Laos under the ASPEC program if first, a patent application in an AMS IP office or second IP office where the ASPEC request form is filed must correspond to a patent application in the other AMS IP office or first IP office. Secondly, the ASPEC request must be accompanied by short and examination document of the corresponding application from the first IP office. Thirdly, all claims submitted in the subsequent IP office must conform sufficiently to allowable or patentable claim referenced in the short and examination document from the other participating patent office. Accelerating patent examination by using the Cooperation for Facility Testing Patent Grant or CPG between Japan and Laos. CPG is a framework based on an agreement between the Japan Patent Office or JPO and other foreign intellectual property office. In accordance with the CPG, when patent applications have been accepted and granted at the JPO, patent rights will also be given to equivalent application filed in other contracting offices without conducting substantive examination if applicant requests. Applicants who are right holders of patent registers at the JPO might acquire patent rights for the identical invention as other IP office, ratifying the CPG agreement earlier by utilizing the CPG. In light of the following, applicants who have a patent granted by the JPO can request accelerated decision on patent in Laos with the DIP. Requirement for making requests under CPG. A. Both the DIP patent application on which the CPG is requested and the Japanese patent application, hereinafter referred to as the corresponding JPO patent application, forming the basis of the CPG request, shall have the same earliest date with the priority date or a filing date. B. The corresponding JPO patent application has been granted by the JPO. C. On claim in the DIP patent application requesting accelerated patent decision based on the CPG has been amended as required, so that the claims are the same as one or more claims in the corresponding JPO patent application granted by the JPO.
A patent application in Laos can be accelerated if you have filed a patent application in China. 4.2. Accelerating patent examination by using the Memorandum of Understanding MOU on Intellectual Property Cooperation signed between China and Laos. The purpose of the MOU signed between the China National Intellectual Property Administration or CNIPA and Lao DIP is to help patent applicants who own valid Chinese patent may request accelerated decision on patents in Laos for patent application which they have filed with Lao DIP. Under this memorandum, Lao DIP would recognize the patent examination results made by CNIPA. Requirements for making requests. The Chinese and the Lao patent application are related. That means they have the same earliest priority date, whether it is a priority date or a filing date. Please note, the Chinese patent and the Lao patent application are deemed related under many circumstances. For example, the Chinese patent is a priority claim by the Lao patent application. The Lao patent application is a priority claimed by the Chinese patent. The Chinese patent and the Lao patent application claims the same priority. The Chinese patent and the Lao patent application are different national phases of the same PCT application, and etc. The claims of the Lao patent application are the same as one or more claims in the corresponding Chinese patent application granted by the CNIPA. Please note that applicants are allowed to delete a part of the claims that were granted by the CNIPA. The rest claims will be still considered to be the same. However, a claim in the Lao patent application which introduces a new or a different category of claims to those claims granted by the CNIPA is not considered as being the same.
Re-register Singapore patent in Laos by using the Memorandum of Understanding or MOU on Intellectual Property Cooperation signed between Singapore and Laos. The Laos IP Office and the Intellectual Office of Singapore or IPOS have signed an a memorandum of understanding or MOU on IP cooperation to allow Singapore granted patents to be re-registered in Laos. In accordance with the MOU, the Laos IP Office can now grant quality patent in Laos based on the search and examination done by IPOS, and the Singapore granted patents can now be re-registered in Laos without being subjected to a local search and examination. The requirements for making requests are eligibility requirements. Firstly, the Singapore patent must be enforced at the time of lodgement of re-registration request. And secondly, the Singapore patent must meet the Laotian requirement for patentability.
Hopefully, our video will answer your questions about related issues of obtaining patents in Laos. Please select a professional IP service provider to work with if you want the business to grow in the proper direction. Thank you very much for watching our video. Goodbye and see you again.